You can text your question at the chat box, ma'am.
Sir,
I am not. You are not audible.
I have one doubt.
तिवारी जी रुकिए मैडम. कौन बोल रहा है? Who is that?
Sir, my name is Anirudh, sir. I have one doubt.
Please go ahead, sir.
Sir, a suit for partition was instituted in the year 1988.
1988. Okay.
So after the death of the husband, the wife filed suit for partition against her in-laws.
Okay.
So as on today, 2024, the suit is still pending.
When is the suit filed, madam, sir?
1988, sir.
1988. Okay. How old is the lady when her husband had died?
She is at late 30s.
Okay. Lady got married?
Yes, sir. Lady got married and she filed a suit for partition against her in-laws.
Hold a second, sir.
ఎవరైతే హ్యాండ్ రైజ్ చేస్తారో వాళ్ళకే ఛాన్స్ ఇద్దాం లేదా డిస్టర్బ్ అయిపోతుంది క్లాస్ రైట్ Anirudh sir, please go ahead.
Unmute చేయండి మేడం. మాది unmute చేయండి.
Okay, sir. Let me repeat.
Unmute
A
చేయండి.
suit for partition was filed in 1988.
Okay.
Filed by a lady against her in-laws after the death of her husband. The suit is still pending as on 2024 also.
All right.
So now, what happened in 1988? The suit was filed for partition. In 1998, after 10 years of the institution of the suit, the in-laws adopted one son.
Okay.
So now the in-laws are claiming in the appeal suit, the adopted son is also entitled for a share. Is it possible?
Sir, as far as Hindu law is concerned, even an Aurasa Putra, Datta Putra rather, he is supposed to be an Aurasa Putra for all practical purposes. He also gets a share in the property, sir. There's absolutely no doubt about it.
Sir, my doubt is, on the date of filing of partition suit in 1988,
Yes.
the adopted son is not in existence.
Even if it's not in existence, if it comes later, in the final decree, there is one judgment of Supreme Court, AR 1967 Supreme Court, which says any number of preliminary decrees can be passed. But this is one of the reasons which can be taken, saying that on the date of suit, the adopted son was not in existence, so he cannot claim a share. Simple. Are you able to understand, Mr. Anirudh?
Yes, sir.
Yeah. You can take that stand.
Yes, sir.
You can ask any questions, sir. This is an open board. This is an open board. I request you raise your hands before you ask a question so that we will come to you. Ramakrishna garu, please go ahead, sir. Ramakrishna garu.
Good evening, sir.
Good evening.
Good evening, sir.
Good evening.
Sir, in what situations a unregistered will gets annuality?
Right. And unregistered will?
Annuality means finality. What do you call? I
Sir,
don't remember the word exactly.
as far as Hindus are concerned, a will need not be registered under Section 18 of the Registration Act. Registration of a will is absolutely optional. The question is definitely under the will, if any bequest has been given, it can be implemented, provided the property that is bequeathed should be within the disposing capacity of the testator or the testatrix. Nowhere it is written that a Hindu will should be registered, sir. Registration is absolutely optional. You need not get it registered, but it requires two attestors who should attest the wills. And the will comes
It is been attested, but past 15 years that is been not challenged. Now, for some other reasons, they filed a partition suit.
Yes.
So
No.
we produced that will.
If
When
you produce the will, the only way of proving a will is to examine the attestors, because the will has taken effect after the demise of the executant, and the attestor who has countersigned it as having witnessed the signature of the executant, he will come and say, I identified the signature. In my presence, the signature was put, and after the signature was taken, I countersigned it as having witnessed the signature. Simple.
For past 15 years, that has been not challenged. And the will which has been discovered past 15 years back,
Yeah.
everyone knows within the family.
Huh.
So after 15 years, they filed a petition saying that they doesn't know the will.
Sir, the question of not knowing the will not arise, sir, because it's constructive notice. Even if the family members, since you are propounding the will, it is your duty to prove and establish the will. Even if they claim a partition, the question, nothing stops them from claiming partition. Of course, at the time of cross-examination, you can confront them with the will and the signature of the testator or the testatrix, and also say that the will is effective in all respects, and you also have knowledge about it.
Okay, sir. Thank you, sir.
Thank you. Mr. Ravi, please go ahead with your questions. He is Mr. Ravi. Yes, sir, is nothing but Ravi.
Yes, Mr. Sir.
Ravi, sir, go ahead with your question, sir. Sir, go ahead, sir. I'm not to hear you.
So can you hear me?
Yeah, absolutely loud and clear.
Can you hear me?
Yes, sir, please.
Hello?
Please.
Yes, sir, Mr. Ravi. Go ahead.
Yeah. But I have a query regarding two parties margina and I am for the defendant, sir.
All right.
So plaintiff and defendant both are agreed on. Hello?
Yes, yes.
Please
carry
go
on.
ahead. Please go ahead.
Sir, can I go for?
Yes, carry on.
Sir, plaintiff and defendant, I am appearing for defendant, sir.
Carry on.
Plaintiff and defendant agreed on property to purchase that,
Yeah.
and they both agreed that, and one advance also taken,
Yes.
and on that grounds they have righted one Purana, and after that they have agreed that to purchase sell the property.
Right.
But after that, what is happened that the seller is not seller, buyer is not interested to purchase the property.
Okay.
So, and after the demise of defendant, ఎవరైతే ఉన్నారో అతను చనిపోయిన తర్వాత కేసు అయితే ఫైల్ చేయడం జరిగింది సార్,
Right.
మనీ సూట్ కింద.
Right.
సో అయితే ఇక్కడ ఏం జరిగిందంటే ఆల్రెడీ ఎవరైతే ఆయన ఏంటంటే ఇప్పుడు ఎవరైతే అమౌంట్ తీసుకున్నారో ఆయన డిఫెండెంట్ చనిపోయారు, ఈవెన్ ప్లెయింటిఫ్ కూడా చనిపోయారు.
Sure.
బట్ ప్లెయింటిఫ్ ఇన్స్టెడ్ ఆఫ్ ప్లెయింటిఫ్ వాళ్ళ అంటే డాటర్ ఇన్ లా షీ వాజ్ అటెండెడ్ దట్
Right.
as a evidence. She
Right.
has given the evidence as a PW1.
Right.
So the court also considered that, and on that grounds, the in favor of the decree, they have passed that in the favor of plaintiff, sir.
Right.
So, నాకు doubt అంటే is that any chance to like appealing for appeal, sir? In this
You can definitely
case.
go by way of an appeal. The question of equities will have to be worked out,
Yes, sir.
because it was jointly purchased by the plaintiff, the dead plaintiff and the dead defendant jointly. At the most, the plaintiff is entitled only for 50% share, not more than that.
Okay. అంటే ఈవెన్ అసలు ప్లెయింటిఫ్ కి అసలు ప్లెయింటిఫ్ ఈవెన్ ఏదైతే ట్రాన్సాక్షన్ జరిగిందో ఆ ట్రాన్సాక్షన్ లో అసలు ఎవరైతే ఉన్నారో డాట్ ఇన్ లో కూడా
Please keep your mic.
నాట్ దేర్ సార్.
Please keep your mic. Please keep your mic before in a proper way, sir.
యా సార్, అది వాళ్ళ కోడలు ఎవరైతే ఉన్నారో ఆవిడ ఆ ట్రాన్సాక్షన్ చేసే టైంలో కూడా లేదు సార్. ఒకటి. రెండోది ఏంటంటే ప్లెయింటిఫ్ ఈవెన్ డిఫెండెంట్ బోత్ ఆర్ డైడ్ సార్, ఇద్దరు కూడా లేరు.
Right.
అండ్ పీడబ్ల్యూ ఓన్లీ ఎగ్జామిన్ బై ద కోర్ట్. పీడబ్ల్యూ అన్నట్టు వాళ్ళ కోడలు ఒక్కటే ఆవిడ ఒక్కటే ఎగ్జామిన్ అయ్యారు. ఈవెన్ విట్నెసెస్ ఎవరైతే ఏవియన్ సేల్ అగ్రిమెంట్ లో ఎవరైతే విట్నెస్ గా సిగ్నేచర్ చేస్తారో వాళ్ళు కూడా ఎవరు కూడా దే డిడ్ నాట్.
Sir, I request you to please speak in English. People are asking.
Yes, sir. Yes, I'm trying, sir. I'm trying.
Please.
I'm trying that, but due to network issues, సో ఈవెన్ ఏంటంటే అందులో బీడబ్ల్యూ ఒక్కరే ఎగ్జామిన్ అయ్యారు. ఈవెన్ దేర్ ఇస్ నో విట్నెస్, అంటే ఎవరైతే కౌంటర్ సైన్ చేశారో వాళ్ళు కూడా ఎవరు ఎగ్జామిన్ చేయలేదు అనమాట. సో because of that reason I'm going to is there any chances to file appeal, sir?
See, the question arises, who has filed the suit? The daughter-in-law has filed the suit.
Kodal, sir, Kodal.
For
Sister.
what?
Daughter-in-law has filed the case.
For suit for what?
Suit for recovery of money, sir.
Recovery of money, she will be entitled only to 50%, sir, because the question is plaintiff's investment is only to the extent of 50%, not more than that. Is it? You can definitely file an appeal and raise a point saying that
yes, sir,
only to the extent of 50% that plaintiff is entitled, the other 50% will have to go to the defendant. You can file an appeal before the appellate court.
Okay, sir. Okay, sir. Okay.
All right.
Thank you very much, sir.
Thank you. Any more questions you have? Mr. Vivo, you have a questions, I hope so. 2249. Mr. Vivo. So there's a question asked here. In the petition for the attachment of the property pending suit, in a suit for return of advance money under the agreement of sale, under what provision the IA for the attachment can be filed?
The provision under which the petition has to be filed is under Order 38, Rule 4 and 5. But after the amendment of in 1976 of CPC, notice has to go to the opposite side. Only conditional attachment can be ordered, and the other side will be asked to furnish security for the for whatever amount you are claiming. And only when it does not furnish security, the property will be attached. If not, it's not done, sir. So ex parte attachment cannot be ordered. Only conditional attachment can be ordered, asking the party to furnish security. That is the position as far as Order 38, Rule 4 and 5 are concerned.
All right, Mr. Vivo, are you okay with that question? What did you get the clarity? Please, if you are not able to connect to net, please put it in the chat box. We will read your question. Mr. Sriram. Mr. Sriram, unmute yourself. Go ahead with the question.
Yeah, thank you. Sir, I have a doubt regarding the Hindu Succession Act 2005 amendment. So there is a like a self-acquired property by the male person. He died interstate, and it was devolved to her wife and 2 children.
Right.
So what will be the shares?
Sir, the shares should be equal shares, sir. 1/3, 1/3, 1/3.
1/3, 1/3, 1/3.
Yes, sir.
Okay. Thank you, sir.
Right.
Any more questions? Please go ahead, sir. Any type of questions, any kind of files, you can go ahead. This is an totally interactive session with our co-advocates and a learner advocates, whomsoever it is. We are here to answer your questions. This is the first time we are coming with the only interactive session. Mr. Rudra, please go ahead, sir. You can ask the question. Mr. Rudra, are you there? All right. So Mr. Rudra is asking it. Mr. Rudra is asking, mother and father died. Both have a deposited amount in a bank and having property. Children will filing civil suit implicated in immovable properties.
Sir, as far as movable property and immobile property is concerned, you can file a common suit for declaration that you are entitled for definite shares because they died intestate. If it was only movable property, you could move for succession under Section 370 to 372 of the Indian Succession Act. Since immovable property also is involved, you will have to club both of them and file a suit for declaration, sir.
Is it okay, Mr. Rudra? Did you get the answer? All right. Please answer if you're okay with it. Mr. Yesudas, please go ahead with the question.
Sir, good evening, sir.
Good evening.
Sir, I filed one Rent Control Act for eviction of suit Section 10, sir, because she is widow.
On the ground, on what ground?
A bona fide requirement, sir.
Right.
For PT business.
Yes, sir.
I have issued in 2009, sir, legal notice.
Right.
He filed that fixed deposit of rents. He filed.
Okay.
The tenant he filed.
Right.
After that, I filed eviction suit.
Right.
I won the case in Secunderabad. He went to City Small Causes Court.
Right.
There also dismissed. He went to High Court.
CRP.
There, yes, sir. There also disposed that he went to Supreme Court, sir.
Right.
He's in 30 years in possession, sir.
Yes.
And I also filed EP also. EP also awarded in my favor. But what happened means, due to ill health, she could not start the business.
Right.
We have medical, but what happened means, in her, she is in hospital. But somebody, I don't know their family, but tenant they've put in one two-let board.
Right.
He filed one IA. To give me, she's not
Occupying.
one of her. Yes, sir.
Right.
But he filed reopen the case and give me possession. He filed one IA, sir.
Right.
What
Well,
do you? I mean, you're not understanding. What do you want the solution from our end?
Is there any ground to ask that a tenant after EP also disposed and everything?
See, the question is already a fait accompli. But under the Rent Control Act, if you carefully see, if you ask for self-occupation, if it is not occupied, there is an option given to the tenant to annul that eviction order on the ground saying that the requirement of self-occupation does not exist.
Yes, sir. But she is hospitalized. Everything is she undergone operation. Medical treatment records also is there.
You can file a counter to that effect saying that because of her illness, she could not start the business. She definitely has the intention and she wants to start the business in the tenanted premises, in the suit premises.
Sir. Thank you, sir. Thanks, sir. Another doubt, sir. I filed a legal hair, but that date of death is wrongly mentioned, sir.
You can file a petition for amendment and say that the date of death has been mentioned inadvertently as a wrong date. Please correct it.
Is there any provision? Is there, sir?
That is
CPC.
not CPC. You'll have to file it under Order 6, Rule 17.
Sir. Okay, sir. Thank you, sir.
Thank you. Mr. Srikanth, go ahead with the question.
Good evening, sir. In a matrimonial dispute, I am representing the husband. And so while their marriage is in good terms, like he purchased the open plot and a 3-storied building in wife's name.
Yeah.
Now she is filing a maintenance case, like for an additional maintenance, and she is not willing to transfer the property to her children.
Right.
All right.
So can we recover? Is it possible to recover that?
Yeah, we
property?
can
You can do it, but provided you come under Section 3 of the Benami Properties Prohibition Act.
But is that clear transactions and it been declared in the ITs and everything?
It is declared in the registered document. It is
No.
that
You're not understanding one point, my dear. You're not understanding one point. See, when the husband is purchasing that particular property in the wife's name, is everything is being funded by husband? How can you prove it?
Yeah, because wife is not working at that time, and also husband is abroad, went for work, and in the registration document also it is mentioned that since the unavailability of the husband, it is being registered in the name of wife.
Perfect. Now you can try in Benami Act and Section 3.
Benami, and also there is one more alternative. You don't want to come under Benami.
Sorry, husband is already an NRI.
If the husband is an NRI, the question is you can say I funded the property, and it's also recitals are there. Nominally is kept in the name of the wife because she is here, and
In
you
India.
can get yourself declared as the owner of the property, and she is only a Benami dar. That is nominally it is kept in the name of the wife.
And it is also mentioned in the in your sale deed or sale agreement. What you are saying is it will be a tool for you to show that he is just a Benami for me. As a wife, I have believed and I have given an agreement to her to register the deed. And now she is coming under saying that she's asking the maintenance.
That's the reason.
Let transfer the property. Then we'll speak about the maintenance. You can see that.
That's the reason. Don't purchase any property in the name of a female.
ఇక్కడ ఫెమినిస్టిక్ ముందు కొడుతుంది ఇప్పుడు మిమ్మల్ని.
And section 14 is there. Whatever estate remains in the name of a lady, it is an absolute estate. In the 14 of the Hindu Succession Act, no question of limited estate or nominal estate, sir. Kindly go through section 14 of the Hindu Succession Act.
Sure. Thank
All
you.
right. Any more questions? Go ahead with your questions. I think there is somebody is asking some questions in chat box. Snehita garu, please go ahead with the question. Sir, in a statement that a lady who has died interstate left behind a daughter and a son.
Does the words left behind mean that the son has also died?
మీరు రాసిన బాగానే రాశారు కానీ it has to be more clear.
See,
can you do it, ma'am?
Yeah, what you
Let her ask the question in a better way so that framing is not right way. Snehita garu, are you there? Snehita garu, Miss Snehita, can you ask the questions on the open port so that we can understand the exact thing? All right, we are keeping your question on hold because the framing is not proper, so that we are not able to understand. Please raise your hands. Mr. Nakul Malesh, please go ahead, sir.
Once again, hand raise chestene.
Please raise your hand to ask a question.
Hand raise chestene, I can unmute them. Hand raise chestene.
Akul Malesh garu, please raise your hand. All right, Akul Malesh garu, please unmute him. I think he will ask a question.
Yes, sir.
please go
So
ahead.
I have one question, sir. Like 3 brothers and 1 sister. So they partition the
Sir,
properties.
please repeat it again, sir.
Yes, sir. Good evening, sir. Is it audible, sir?
Yeah,
Yeah.
please repeat it.
Yes, sir. So there is 3 brothers and 1 sister in the family,
Yeah.
and they have the properties in Mumbai as well as in Telangana, and they partition all the properties in 2005,
Right.
and they position.
Yes.
After that, they did not file or they did not written any document.
Right.
So which are the properties belongs to first one, second one, third one.
Okay.
So after that, 2012,
Hmm.
the elder one
Hmm.
again filed a suit for second one's property.
Right.
So now how he is going to protect his property because there is no proper document,
Hmm.
and so how he is going to dismiss the suit which the elder one filed?
Sir, the question is, once a preliminary decree is passed, only, only the respective shares should be allotted. But next step you have to take by filing a petition for final decree under Order 20, Rule 18, and also under Order 26, Rule 13, to demarcate and localize your property and to hand over possession to you. If you have not done it within 3 years, you ought to have done it. If you have not done it, you explain the delay and then file a petition under Order 20, Rule 18 to pass a final decree and for appointment of commissioner to locate your property and hand over possession to you, sir.
But sorry, they did orally, sir, with all the elder people in community. They did.
Then in that you raise a defense saying that already it was partitioned orally before the elders, and you examine one of the elders who was present at the time when the division was done, and through them you try to establish that the respective allotments were made during oral partition, sir. You have to examine one or two of the elders to say that in their presence the property was divided.
Snehita can ask the question in
Those
a
are not
better way.
available, sir. They passed away, sir.
Then
The
the
elder people-
then the children can be examined, sir.
Okay, sir. Okay.
All right. Mr. Rudra, you have a question, I hope so. But she's not ready to ask the question in the open forum. She's not ready. All right.
Snehita garu better.
No, chat box is not clear, sir. Rudra garu unmuted and Rudra garu mute చేశారు. Rudra garu unmute చేయండి.
Search them.
రుద్ర గారు ఇక్కడ ఉన్నారు. సెకండ్ ఉండేకి వెళ్ళి రుద్ర గారిని అన్మ్యూట్ చేయండి. All right, Rudra, you are unmuted. You can ask the question.
Hello, sir. Good evening, sir.
Good evening.
Sir, my question is, sir, already asked the chat box, sir. Hello.
Please repeat the question, sir.
Sir, mother and father died, sir, both.
Right.
Sir, parents have deposited some amount in the bank, sir.
Right.
So both are dead, sir. And another property, having another property, sir.
Okay.
So children's how to go into the civil suit or sir SOP ante double కట్టాలి కదా sir మళ్ళీ దానికి.
అవును.
అంటే movable or immovable is implicated in the suit, civil suit, sir.
You can file a suit for declaration saying that as far as the movable and immovable properties are concerned, you have got a share in that, and your share should be allotted to you, and you be declared as the sharer or the person entitled to draw the money as well as your share in the property. Because there are class 1 heirs under section 8 of the Hindu Succession Act.
ఓకే. ఇప్పుడు దాన్ని తీసుకొని మనం బ్యాంకులో కూడా సబ్మిట్ చేయొచ్చా సార్? ఇప్పుడు మనకు డిపాజిట్ అమౌంట్ కానీ
మూవబుల్ అండ్ ఇమ్మూవబుల్ రెండు ఉంది కాబట్టి you will have to go by civil suit only. You can't go under the Succession Act.
Okay, sir. Thank you, sir.
Anirudh, Mr. Anirudh, please go ahead. Mr. Anirudh.
Yes, sir.
Please go ahead with the question.
Sir, this question is relating to Constitution.
Right.
In Article 1, we have a name, India, that is Bharat. In Article 393, we have short title. This is called Constitution of India.
Yeah.
So what is the difference between name and title?
See, Constitution of India is, you will have to read the preamble. If you see the preamble, Article 1, Section 1, Article 1, it says that we, the people of India, constitute ourselves into a sovereign, democratic, secular republic, and guaranteed to our citizens the right of equality, fraternity, and that's also, that's the preamble. It applies only to the preamble, sir, and it applies to the entire country except the Jammu and Kashmir.
Sir, not asking about applicability, sir. In general, what is the difference between name and title?
Name
in Article 1, we have name.
What is the name given?
India, that is Bharat, shall be a union of states.
See, yeah,
that is the name.
Yes, sir. I'll tell you. I'll explain each one. See, previously, when the independence was granted in 1947, we had the princely states also, sir. Actually, we had the princely states and which merged with the Indian Union, and Nizam state was the only state which did not merge with the Indian Union. So police action was ordered by Sardar Vallabhbhai Patel, who was the Home Minister, and where Hyderabad Nizam surrendered, and ultimately Hyderabad became a part of the Union territory. And now you've got what is called we are a federal structure of the Constitution. We have the federal structure. That means we have the fulcrum, we have the union government, and below them you've got the provincial governments or what is called the state governments. Each one has got independent powers. That is, list 1 deals with the legislative powers of the union. List 2 comprises of the powers of the state, and list 3 is a concurrent list where both the union as well as the state can legislate. That is what is called the first part of it, the question which you asked. But as far as the word state is concerned, state means a union of India. That is a union of India with the provincial states. That is called the Union of India. That is what is called the the union government, or what is called the central government, sir. Are you able to understand, sir?
Anirudh Garu, are you clear with your doubts? Muted enter. Anirudh Garu. And Anirudh Garu, unmute చేయండి. మీరు ఒకసారి చూడండి. Anirudh garu, you can go ahead with it. You can unmute yourself.
Yes, Mr. Anirudh.
Are you clear with your doubt?
Is there any problem?
Vivo can ask the question. I think. Yeah, please go ahead with Vivo. Still muted, enter. Anirudh garu. You unmute yourself, sir. You have a chance.
Yes, sir.
Yes, Mr.
Yes,
Anirudh.
yes. I got the pop-up. Yes, yes, sir. Thank you.
Right.
All right. Thank
I
you.
got.
Mr. Sam.
Mr. Sam, please go ahead.
Yes, Sam.
Yeah, good evening, sir.
Good evening.
Sir, there is a shop, sir, which has been allotted by SCST Act. I don't know, sir. That shop has been allotted to a lady, sir, a woman. But she was in the possession and she paid all the taxes for almost last 20 years.
Right.
So very recently she has given that outlet to rent for someone.
Right.
But it is against, as per the rules of SGST
Right.
shop act. But she has given that rent. Actually, now that person has occupied that property, not paying any amount for rent for almost 1-2 years.
Right.
And he's threatening her.
Right.
Now, and they filed a suit for eviction because ideally this is, obtained by the government for this thing. She cannot go for suit for eviction.
Right.
And she approached the collector office as well. And I don't know, they didn't give a favorable kind of response to her.
Right.
So what is the remedy, sir?
The remedy is to file a suit, no doubt, for eviction, and also the arrears of rent, whatever, because Section 109 of the TP Act says, even if a person with defective title inducts you into possession, he is deemed to be your landlord, and the tenant cannot deny the title of the landlord, irrespective of whatever defects may be there. And in case it does not follow the terms of the lease, he has to pay the rent. He has definitely to pay the rent, but he does not pay. Then you can file a civil suit. There is no bar at all. But you can also file a petition under Section 15A of the Civil Procedure Code. Ask him to deposit the entire arrears of rent and future rents also. And in case he does not do it, under 15A2, you can file the certified copy of the order in 15A1 and ask the court to strike out the defense and put you into possession of the property. You will have to just go through Section 15A1 and 15A2 of CPC, sir. That is included by the Amending Act of 1976 CPC.
Sir, but here what the collector has said, right? This is not your property. It's the property of the government.
Right.
You cannot rent it out to the other people.
Okay.
This is what the complication is now.
See, your terms of allotment, you'll have to see, sir, whether there is any restriction imposed on leasing out, number one. Mostly, what my impression is that there should be a restriction in respect of alienation. There cannot be a restriction regarding letting out, sir. Just look into that provision.
Yeah, sir. It's SCST Welfare Association from the collector office. It was allotted.
Right, sir. You see the condition whether it can be let out or it should not be alienated. If it cannot be alienated, well and good. If the question is it cannot be let out, then there is a restriction imposed. Or you give a statutory notice to the collector. This is the factual position. Please give us permission to initiate legal proceedings against the tenant who has defaulted in payment of rent. The question is, suppose there's a restriction not to let out, then the question arises, sir. Just go through the allotment first.
Yes, sir. We have sent a legal notice to that, sir, stating the same reason what you have said.
Right.
But no response from the collector.
Then you do one thing. You file it against you file it against the tenant as well as the collector, sir.
Okay. We have to approach the High Court, sir?
Not necessary, sir. You can file a civil suit. Writ doesn't lie for this.
Okay, sir.
Or if you want to file a writ, you can ask the High Court to clarify regarding this position.
Okay, sir.
Let's Sam. I have a question from Vivo. Are you there in Vivo? I don't think so. Mr. Prashant Nyayapati. Mr. Prashant Nyayapati, we are unmuted you.
Yeah. Sir, good evening.
Good evening.
Kanthanam, good evening, sir.
Good evening, sir.
Sir, this is with regard to the question which I have. Generally, courts are passing interim injunction orders. Along with that, the petitioner advocates are filing with regard to the police protection orders under 151 CPC.
Yes.
And generally, sir, there are judgments to the effect that the junior courts and the senior courts and district courts are not empowered to pass orders of police protection, and the parties are advised to file a petition under Order 21 Rule 32. This is with regard to some confusion, sir, with regard to.
No, there is no confusion, sir. Just go to the judgment of Justice Sumalata. I think it was passed in 2020 or 2021.
Yes,
the entire ambit of police protection was discussed by her in detail, including the Supreme Court judgment. She said only the police can implement the injunction order and the court cannot refuse police protection.
Yes, sir, but even though that judgments are cited before the courts, but courts are even nowadays recent also about cases with regard to that, and they are even junior courts and senior courts are passing the same orders in spite of the orders passed by Her Lordship Justice Sumalata.
Under Order 21, Rule 32, comes only
yes,
when the
yes,
suit is
violation
decreed.
of orders.
Suit is decreed, not otherwise. Or file it under Order 39, Rule 2A.
39, 2A.
Yes.
2A. Yes,
Disobedience.
Yes. Thank you, sir. Thank you, sir.
Mr. Weaver 2249, you can ask the question here. Can you ask it? All right. iPhone. Mr. iPhone. Please unmute yourself and ask the question.
Chat box not given.
Sir, chat box is very big. All right, Mr. Nokia. Ganesh Garu, please go ahead. Indru Ramprasad Garu. Where are you, sir? Ramprasad Garu, you are unmuted. You can ask the question, sir. Please go ahead. Ramprasad Garu, are you there? All right, we are skipping Ramprasad. Ganesh Garu, go ahead with the question, sir. We are unmuting you. iPhone, Mr. iPhone, you can't explain. You are saying it. It is in the hearing. I understand. Please go ahead with the questions. No problem. You can speak in and whatever the language it is possible for you. We give a chance to you. Please go ahead with that. Please wait for a minute. Mr. Ganesh, please go ahead. Mr. Ganesh, you are unmuted. You can go ahead with the question. Mr. Ganesh. Right, we have to give a chance to another guy. Nokia. Jamuna Tiwari, please go ahead. All right. I'll give to Akul Mahesh. Please, Akul Mahesh Garu.
Thank you, sir. Thank you. So there is one matrimonial case.
Please keep your mic. Please keep your mic properly so that you are audible.
Is it better, sir? No.
It's better now.
Yeah. So there is a matrimonial case. So they're married, I think, 8 years back, and there is a one kid. So 3 years back, she left from the home without informing to husband, and where they are, he doesn't know. So their family also, they changed the house. So how we can move on to this particular case, sir?
Where is she residing?
So she reside in, I think, Nirmal. But
you'll have to find out from the concerned police or the concerned locality or the ration shop from where she is residing, sir, because the changed address must have been given there.
But police also, they're not able to track where she is.
Yes.
And so how to proceed from husband's side?
So the question is, as far as the husband is concerned, you say she has abandoned the place. She has gone to some place which I do not know. In spite of my best efforts, I could not find out her address. You take out the summons on the known address only. Let it come 3 times and then take publication and take an expiry order.
Okay, sir. Thank you, sir.
Right. Next, Nokia Tiwari, Jamuna Tiwari ji, आपकी बराई है. We are unmuting you. Please go ahead with the question. iPhone, we are going to give a chance. Please wait. Jamuna Tiwari ji.
Sir, hello.
Yes, ma'am.
Sir, Article 61 and 62 of Limitation Act. Once I can explain.
Yes. Article 61 and 62 of the Limitation Act deals with limitation period for redemption as well as for foreclosure. I mean, only for redemption, madam. Here, 61 and 62 says the period of limitation is 30 years as far as the mortgagor is concerned. And as far as the mortgagee is concerned, it is 12 years. It is 12 years as far as the mortgage is concerned. That is Article 61 and 62 of the Limitation Act. And mortgagor is concerned, it is 30 years.
Any more questions?
Sir, అందులో టెక్స్ట్ బుక్ లో అది 12 years అని ఉంది. ఆర్టికల్ 61 కైనా 62 కైనా లిమిటేషన్ యాక్ట్ టెక్స్ట్ బుక్ లో నేను చూస్తే నాకు రెండిటికి 12 years అనే ఉంది. 30 years, 20 years equal to
12 years as far as enforcement of mortgage is concerned. But as far as redemption is concerned, it is 30 years, provided the right of redemption is not extinguished by a decree of the court.
ఆర్టికల్ 62 లో కూడా అదే ఉందా సార్?
అవునమ్మా.
సార్, రెంట్ కంట్రోల్ లో ఇంపార్టెంట్ సెక్షన్ చెప్తారా ఒకసారి?
మళ్ళీ చెప్తాం మేడం. కొంచెం మిగతా వాళ్ళు కూడా ఉన్నారు లైన్ లో. విల్ కమ్ బ్యాక్ టు యూ అగైన్. జమునా గారు, ప్లీజ్ వెయిట్. ఓకే, రామ్ ప్రసాద్ గారు. రామ్ ప్రసాద్ గారు, ఐఎమ్ అన్మ్యూటింగ్ యూ. You can unmute yourself and you can ask the question. All right, and I'm giving an iPhone. Mr. iPhone, please go ahead. Mr. iPhone. Mr. iPhone, you are not unmuting yourself. All right, next is Ali Khan sir. Ali Khan Mir sir, aap?
Hello sir.
Yes.
Hello sir.
Please go ahead, Mr. iPhone.
Sir, in Muslim law, sir, deceased have 2 wives, sir. 2 wives and 8 children.
Yes.
2 children are minors, sir.
Right.
Still.
Right.
Sir, he has two properties. One is in Hyderabad, and one is in Nizamabad, sir.
Right.
Their deceased died in 2023, sir.
Right.
But they have not filed any legal certificate and succession certificate.
Right.
Present, they wanted to sell the property, one of the property, sir.
Right.
Only half of the property, sir. In that,
right,
half of the property they wanted to sell. Remaining property they wanted to they wanted to use further, sir.
Right.
Sir, what they want to do, sir?
You must file a suit for declaration saying that the two wives plus the children are entitled for the legal status and entitled to the property according to the shares in Mohammedan law. and then take the declaration, and based on that, you can do it.
Okay, sir.
Yeah.
And
the minors
sir,
will have to
what
be
about-
represented by the guardian.
Okay, sir.
Yeah.
Okay, sir.
In
Sir,
the
what is the procedure, sir? What is the procedure, sir?
Procedure is you will have to file a suit for declaration that they are entitled to the legal status and successors to the property left behind by the deceased. And in case you do it, you will have to pay half the market value of the property in order to get a decree, sir.
Okay, sir. Thank you, sir. Thank you.
Indru Ram Prasad garu. Are you there, sir? Ram Prasad garu. Already Indru Ram Prasad garu keeping it on. Mirza Ali Khan, sir.
Yeah, I get it.
Ali Khan Mir, sir. Please unmute yourself, sir. He's not there, I hope so. Ramakrishna garu, Binigi. Madam, అందరినీ అన్మ్యూట్ చేయడానికి వాళ్ళందరూ వాళ్ళకి ఇవ్వడానికి మన ఛాన్స్.
Snehita never.
Madam, give a chance to unmute themselves.
Sir, good evening, sir.
Yes,
This is
yes,
Ramakrishna.
Yes.
Sir, I have sent one extra clause from a sale deed.
Yeah.
The third clause, I need some clarification regarding that because
You
I
kindly-
am one of the vendor in this
Wait, I'm showing it.
sale deed, sir.
Okay.
Thing is, we have 3 brothers and sisters.
Yes.
There are 2 properties in the name of my mother,
Yeah.
ఇది అయిపోయింది.
and upon oral partition,
Yeah.
mother has given
Hmm.
commercial building to daughters
Right.
and the agricultural land to the sons.
Right.
I am one of the son
Right.
among 3 sons.
Right.
I need clarification on these third paragraph, the third one, sir.
Which you
Second
have
paragraph.
highlighted. Whereas on oral partition, the property, the vendors number 1 to 5 got the scheduled property, and whereas the vendors 6 to 8 got other properties which are standing in their names, in which the vendors 1 to 5 have no share, and for the property standing in the name of the vendors 6 to 8, they are absolute owners. On further oral partition, the rare portion of the property exclusively allotted to vendor number 1, and this rare portion is the absolute property of the vendor number 1. Yes. So,
Vendors 6 to 8, one among them.
yes, sir.
I am one among them, 6 to 8.
That is as far as immovable properties
So,
are. Yes.
Yes, sir. Yes, sir.
Then, as far as immovable properties are concerned, you will have to claim for partition and claim your 1/3 share or whatever it is, sir. Because the 6 to 8 is 3 people,
Okay.
isn't it, sir?
Yes, sir.
So formally make the daughters also a party and rely on this clause saying that the movable property was commercial property was given to the daughters and there is already partition effected as far as the daughters are concerned. But as far as the sons are concerned, they are given in equal shares, that is 6 to 8. That is 1/3, 1/3, 1/3. To the extent of 1/3, you can ask for partition, sir.
But I got confused, but still.
No, 1/3, 6 to 8. 6 to 8 have got the other property jointly, isn't it, sir?
Yes, sir. Yes, sir.
So that property you are entitled for a 1/3 share, isn't it?
Okay.
So you claim your 1/3 share. Ask it to
Sir,
be ask
my
it,
mother has been
ask it to be
without registering that. Sir, after this registered sale deed, that other property which is given to us on oral partition, that is being not transferred on our names, sir.
even if it's
Just
not
only we
transferred.
did
Now,
that
now, now,
agricultural
now,
land.
now we ask for that and say that because it's undivided and not partition, let 1/3 share be divided and given to you. There's
But
no need
meantime,
of
even
no,
before that, sir,
no need
even
of
before
no,
asking that partition, they filed a suit for partition, sir.
right. See, no need of going for declarations. So straight away you can file a partition suit.
Okay, sir.
That is my humble opinion, sir.
Anurag garu, please go ahead with the question.
Thank you, sir.
Yes, welcome.
Anurag
Yeah.
garu.
Thank you, Kalyan Garu. Sir, good evening.
Good
This
evening.
is Anuradha.
Yes.
This is with regard to my elder sister's self-acquired property,
Right.
which she got. She purchased a plot in 1986, and she got it constructed in the year 2005.
Right.
And the extent in the document happens to be 250 square yards.
Right.
And she died in 2010, sir.
Okay.
So the neighboring plot was an empty plot when she
Right.
purchased.
Right.
And she gave it for development
Right.
to a contractor.
Right.
So without going into the extent part,
Right.
she just got it constructed.
Right.
And we are 3 siblings. She is unmarried,
Right.
and we are 3 siblings.
Right.
So what happened was she just got it constructed as she was alone,
Right.
without getting into the extent,
Right.
being corrected.
Right.
So now we found that there is 25 square yards
Extra.
of the extent is missing.
Right.
I found it recently.
Right.
So what happened meanwhile, there is a second owner who has
Right.
entered into the neighboring plot,
Right.
and he constructed the house 8 years ago.
Right.
And the extent which we are missing in the plot,
Yes.
my sister's plot,
20
happens to
25 square yards.
be in the neighboring plot.
Right.
He has extent land.
Right.
And so we went and personally tried to talk to him. So he agreed to that,
Right.
because while construction, they could see some extra area in their plot,
Right.
which he orally accepted.
Right.
And but now he's changed his words, saying that how can I part with
25
such
square
an
yards.
extent?
Yeah, 25 square yards.
Yeah.
No. So the question is, oral talks which you had, were there witnesses for that?
No, sir. It was only me and my husband.
Then you will have to say that there was an oral arrangement stating that that fellow assured you so much. Which year this happened?
This happened recently, last year, sir.
Last year. You said this happened and
Yes.
he has not implemented it. Let him hand over to 25 square yards of excess land from my property, which has gone into his property. That has to be re-delivered to you, and you file a suit for recovery of the 25 square yards.
Okay.
Based on
Initially,
the-
should I send a notice, sir?
Better.
Notice
Based on the
saying that-
base, and remind him of the oral assurance which he has given to you.
Okay.
Yeah. Let us see what defense he takes.
Okay. And I requested him to part with his plot documents also,
Right.
which is not doing that.
You will not do it. Or
Saying
you are, in the notice itself, you say, please furnish me a Xerox copy of your property documents for proper inspection.
Okay.
Right?
And do I need to, after sending the notice, do I need to file a case, sir?
You have to file for the
Supposedly
25
that's a-
square yards. 25 square yards of land which has gone into his property.
Okay.
Then for that, you must take out the layout and also find the respective areas of the plots, madam.
Okay.
Yeah.
Do I need to pay any court fee, sir?
For the 25 square yards, whatever is the market value.
Okay. So the time is not a
No, not
limit?
at all, because you said that oral assurance was given to you last year. And that's the
Yeah.
reason why you kept quiet. Or you can go for specific performance and say that oral assurance to be implemented.
Okay.
Yeah.
Yeah, that I think that would be more effective.
Because that will be within 3
For-
years.
Specific performance would be more effective.
Except for
Stressing
the-
for that would be,
For that oral assurance.
yeah.
Right,
Okay,
madam?
sir.
Right.
Thank you so much.
Sir, sorry to disturb. Even if without witnesses also can file, sir.
You create,
Oral assurance.
you create witnesses, madam.
Okay, okay.
You
understood,
create
sir.
witnesses.
2249. Vivo 2249. స్నేహిత గారు ఐఫోన్ ఇంద్రుడు రాంప్రసాద్ గారు అలీ మీర్ ఖాన్
అలిమీర్ అయిపోయింది.
Hello, sir.
Yes.
Hello,
iPhone.
sir. One doubt, sir.
Yes. See, if you raise your hand, it becomes easy for us to trace, sir. We have also cautioned at the beginning itself, please raise your hands before you ask a question.
Okay, sir. I'm using very rare, sir.
Yeah,
Confusing.
Yes, sir. Please go ahead.
Sir, is there any procedure to follow the PAN is changing the name and survey numbers are merging and dividing, sir?
See, the question is previously revenue officials were doing it, but now there is a provision under the specific relief act called Section 26. If there are any mistakes or deletions, you can get it corrected by filing a suit for rectification under Section 26 of the specific relief act before a civil court. And the court fee what you pay is under Section 43. Only 15 rupees is corrected, sir.
Section 43, sir.
For Section 43 of the Court Fees Act, you pay the court fee. That is only 15 rupees you pay. And you have to file a proceeding under Section 26 of the Specific Relief Act for rectification.
Sir, one more thing, sir. Sir, one of the property in urban area, sir.
Right.
Sir, present before that it is agricultural land, sir.
Right.
So some of the members non-layouted plots and merging in that property, sir.
Right.
And they showed that property and sell some of the plots, sir. And my client have a in the name of his expired his mother, sir, on his mother, sir.
Right.
She's died in 10 years back, sir.
Right.
Sir, what he can do, sir?
You can do one thing. You can take certified copies and say that you have come to know about the same only recently.
Yes, sir.
And then say from the date of knowledge, you say that it's 3 years, right?
Sir, okay, sir.
Yeah.
Thank you, sir.
Sir, Bade sir.
Sir, good evening, sir.
Good evening, Mr. Mohammed.
Sir, this question is regarding to Mohammed-in-law.
Yeah.
Sir, in one family, total 4 brothers, 2 sisters is there, sir.
Yeah.
So recently, within a 1 year, mother, father, and elder son.
Yes.
3 members has been died.
Right.
And the thing is, whatever the properties is acquired by the father, that was in the name of mother.
Right.
So mother also died.
Right.
The question is whether the son who is died before of these 2 persons,
Right.
mother and father,
Right.
before son was died.
Right.
So whether the son family members, legal heirs, will have the right to get the shares in the property.
See,
of
whatever that the dead son had a right, the same thing is heritable, and the children and the widow also get the rights, sir. They step into the shoes of the deceased. There are no 2 opinions about it.
Sir, no, the thing is, as per I heard that as per the Sharia, if father, mother alive before them, any son or daughter will die, they don't have the right to collect the share.
No, sir, I'm sorry about it, sir. Actually, they get a share. It is heritable.
Okay, sir.
Right.
Thank you.
Thank you, Mr. Ravi. Mr. SR.
I'm getting
From defendant, plaintiff and defendant joint sale. No. Sale agreement due to the paid unpaid amount. Also, site is under court litigation. After the transaction not completed, the transaction not completed. Then the plaintiff filed a suit against the defendant in death and the first defendant, and the plaintiff both legal heirs added to them, and daughter and son-in-law gave the evidence. PW1 and the evidence examined. The court passed the judgment in favor of the plaintiff. Kindly suggest the Valid point appeal.
See, the valid point for appeal here is, since the property was purchased jointly by two people, the question is only that lady was entitled only to 50%, even if she inherits the property of her husband. The question is, other 50% will have to go to the other purchaser or his legal heirs. So the question is, definitely can appeal be filed, and also say that as per the interpretation of the document, it's a joint purchase. How much each one has contributed, no one knows. So the question under Section 45 of the Transfer of Property Act, when the respective contributions are not mentioned, each one is entitled for equal share. So only the court could have passed a decree only to the extent of 50%, and the other 50% will have to go to the legal heads of the defendant. So that is the legal position, sir.
All right. I think Vivo is not there. So many people are.
Namaste.
Yes.
Guru gariki namaste.
Namaskaram, sir.
Sir, ఒకటి బ్యాంక్ రిలేటెడ్ గా ఐఎమ్ నాగచంద్ర అడ్వకేట్ సార్.
Yes, sir. Please go ahead.
Still the bank related question, sir.
Yes.
One, my client is the bank was told 138 installment you must pay, but he was paid 145 installments paid.
Okay. How many installments have to be paid?
145 installments paid.
Paid. How much is still remaining?
Then, no remaining the installments are there, sir.
Right.
But bankers were asking another 1 lakh due your account. They are asking to me.
Towards what?
The fluctuation interest also included in your accounts, and they are holding to me.
They are not.
Installment is 9,700 only.
Sir,
but we are paid 10,000, 20,000. I regularly paid that bank, sir. What can I do, sir?
Sir, you do one thing, sir. You kindly forward the papers so that we can go through it and then give a considered answer for that, sir.
Okay, sir. I can meet you, sir.
Yeah, you can do it to Mr. Kalyan, sir. He'll forward it to me.
Okay. Thank you, Kalyan, sir. I will meet you, sir. I am coming to Secunderabad court also, sir.
All right, sir.
Thank you, sir.
Thank you.
Another question is one of the, sir, newly NI Act, the question, the notice is definitely sent to accused, sir. Newly.
Notice has to be sent under 138 statutory notice. Then summons are under 140, 143 or 144. It has to be sent to his known address, that is office address or residential address. And it is normally...
Now, newly, the first legal notice I will send there, sir.
Yes.
But newly, the number is not doing the Elbinagar court, sir.
Right.
You must send it to accused, notice to accused. They are holding, sir.
Then you just kindly go through section 144 of the NI Act, which says it should be sent to the residential address or to the office address of the accused.
After legal notice, notice also.
After legal notice, you file a complaint, isn't it, sir? Then the sworn statement, court takes cognizance of it, sworn statement is recorded. After that, the summons are issued to the opposite side under section 144 NI Act through court and registered post. And then it is normally served through the police.
Taking the sworn statement are not taking, sir.
No, normally what we do is we file the type copy itself. Courts are so lazy, they don't record it. They ask you to file a typed copy of the sworn statement and then they sign it.
I am already filed, but they are not giving the number.
No, they'll give it, sir. They take their own.
Then ask them to give it.
Take their own time to number it, sir.
Sir, take an SR number and ask them, so they'll answer your question, sir.
Okay, sir. Okay.
All right. Thank you. Any more questions, sir? Or can we conclude the day for today? Every Sunday will be an interactive day.
Hello.
Please.
Sir, can you tell, sir, may you tell the important question?
Please be a bit
louder. Your network is breaking up and your voice is not clear.
Sir, I'm hearing you.
Please
You
carry
are
on.
audible for me. You are
Please,
audible for me.
You are not audible for us, for us, madam.
Please carry on. Please carry on.
Sir, may you tell the important questions from the Rent Control Act?
You are asking the provisions for eviction, isn't it?
No, sir, I'm asking important sections from Rent Control Act.
Sir, Rent Control Act, the important sections are Section 4, Section
Sir,
8.
I'm right.
Yeah, Section 8, Section 9, Section 10, Section 11, 12, 11, 12, 14, 20,
Okay, sir.
and 22.
Okay, thank you, sir.
Thank you, and we are concluding a day for today. And every Sunday will be an interaction day from
Please
now
ask
onwards.
them to raise their hands and custom.
Every Sunday will be an interaction day. We'll have an interaction session. You can ask any questions here on our open portal. Please raise your hand before you ask a question, and please address your name and bar association from which place you're calling. Thank you very much. Have a nice day.
Thank you, sir. Thank you, sir.
Thank you very much. Thanks to one and all.
Thank